deeper exploration. For some, guides and helps resolve the dispute. For some others, we feel that the presence of advocates in the mediation room can be disruptive. That they bring positions, they hold the line, and they slow the process. In fact, we often hear some mediators say this, only half in jest, that matters might move faster if lawyers are stopped. This may not be the dominant view, but it deserves a conversation, especially as we enter the post-Mediation Act era. The title of this discussion is deliberately made provocative. It is meant to draw attention to a question we believe is both important and timely. Before we move on to the panelists, let us find out from you audience what your preliminary view is on this topic. Do you really think that lawyers are sidelined in mediation? Can we please have a show of hands? How many of you think, yes, lawyers are sidelined in mediation? Please raise your hands. No judgments, please raise your hands.
Nobody.
So please don't provocate them. Can we please have a show of hands? I can see one hand. Can I see that hand a little more up, please? Yes, that's good. Yes, that's good. Anyone else? Let's assume that there are no mediators on the floor. Okay. that is one hindrance. Okay. How many think that is a no? Okay, that's quite a few. Interesting. So, Sreelal sir, let me start with you. You saw the poll, right? And how the audience think about the role of lawyers in mediation. In the current reality, what do you think are lawyers the core cousins in mediation? Quick comments on this.
I would say as it stands today, to an extent your topic is relevant. We apparently make it appears. There are multiple reasons why you feel that. The mediators certainly feel that the presence of the lawyers, not everyone, to a great extent, doesn't serve the process. Not that they are disruptive. It doesn't serve as it should have been, and they don't support the process going forward. So probably they feel, yes, to an extent, they're pretty bad cousins, I would say. It may not be realistic in all the cases, for some at least, they come into this situation.
We get that. Okay, to John sir, we know that we were not so happy with the title of this discussion as such. So what is your take on it? Like, what is the current practice? Are the lawyers actually sidelined?
Actually, I don't believe in this title. And I don't agree with Sreelal's opinion, sorry. Thing is, according to me, lawyers have a very important role to play in mediation. In fact, in all mediation, due respect to the lawyers and make them part of the process as much as possible. And I'll just ask you one question. Who is the most important person in a mediation room? Is it the mediator or the lawyers or the parties? Parties, yeah. But still, there are some mediators who believe they are the most important person in the room. Some sort of misunderstanding occurred during the first, from 2009 when the first training occurred. There was some miscommunication, misunderstanding, and some mediators took it upon themselves to think that they are the most important person in the room. And it had its issues, and many lawyers, other mediators, and even mediator trainers have told me of their bitter experience with respect to going to for a mediation, and the mediator asking them to go out That was happening maybe the first 5 or 6 years. But now it has changed. The scenario is changing fast. During the last 5 to 6 years that we've conducted a lot of training all over Kerala, and we specifically tell the trainees that you must give due respect to the lawyers. You should make them feel at home in the mediation room. And I believe that it has changed now. That perception is changing for the better. And now I feel the lawyers are also realizing that they play a huge role in this mediation process. And let me ask you another question. Who does the litigants trust? Will they trust a mediator, a stranger, who they are seeing for the first time, or their own chosen lawyer? Lawyer, of course. So if the lawyer is there, the litigants will feel more comfortable, relaxed, and they'll be more prone to divulge their secrets. And the mediation will be a much more bigger, better success. And to my experience, as a mediator for the last 16, 17 years, all the lawyers who come before me has always cooperated and participated in the mediation process. And I am very happy to report that I got good results only because of the participation and support of the lawyers. Thank you.
Thank you, sir. To Rajesh, sir, you seemed quite happy with this title. What is your take on it?
Which is true. I understand that things are changing, but I think I will stick with Sreelal sir on that. I think the lawyers do not get the respect which they deserve. Yet, I don't think they get enough money. And as professionals, that is extremely important to get the right amount of money out of whatever services we provide. So for both reasons, I think the title, I would say yes to the title. Yes, the lawyers currently, I think, are sidelined in the sense that their full potential has not reached yet.
Okay, sir. So in this point, now let's try to understand the real place, influence and potential of lawyers in mediation. So I would like to ask you, Rajesh sir, because you have always been vocal about the wide role of lawyers and the bigger opportunities about it. So can you enlighten us with this wider role of lawyers in mediation?
Yes. I believe as Pallath sir has mentioned, I think lawyers are central to mediation. I dare say that. This is why I think we can see two pathways for a lawyer in mediation. First one, which you are familiar with, is becoming a mediator. Lawyers are best placed. They are not the only ones who deserves to be a mediator, because some of the counselors, psychologists may do a better job than lawyers in the process itself, but they are well placed to become a mediator. I'm not going to talk about that. What is often ignored is the mediation advocacy bit. How the lawyers, not being the mediators, can intervene in a mediation. I would think there are two stages to it. The first is around the mediation process, which means as strategic advisors, the clients come to lawyers, they ask, is mediation advisable? Though the lawyers act as the gatekeepers and advisors as to whether a particular dispute is suitable for mediation, their whims and fancies may influence that decision, but still they are the arbiters when it comes to who or which dispute should go to which dispute resolution process. So I think as a strategic advisor, lawyer has a role. Secondly, when it comes to drafting, sometimes there are two agreements in a mediation. One is the agreement to mediate, and the other is the mediated settlement agreement, which happens after mediation, if there is a settlement. So in drafting those two contracts, of course, lawyers are best placed. and usually they do the drafting of the mediation agreement and the mediated settlement agreement. And then there is a question of compliance. Assuming that some of the parties decide not to comply, lawyers can wear the hat of enforcers as well. They take the parties through the enforcement and the execution proceedings. So this happens around the process of mediation. In the process itself, I think that is where lawyers are alienated. They don't, except that Pallath believes that it's changing, which I agree to, but it hasn't changed enough that lawyers are not recognized as negotiators for the parties. They are party representatives, but mediation as a concept the whole idea of mediation is it is a facilitated negotiation. There is a negotiation between the parties or between the party representatives, which are lawyers, and then a mediator just facilitates that talking, the dialogue between the parties. So as a lawyer, this negotiation role is often misunderstood, not explored enough, and I think that is where the biggest role a lawyer could play. The reason is this: at the end of the day, mediation is going to be about resolution of the disputes. As negotiators, not the mediators are deciding the matter for you, it's the negotiators talk to each other and go through the process and come up with a solution, if at all. So in that sense, I think lawyers have a very central role. First, as around the process, as I said, drafters, advisors, enforcers to some extent, and then in the process, they are the negotiators.
George sir, I would like to ask you one thing. You had recently authored 2 articles, basically, which was the very first one was saying regarding that stepping into the role of a mediator, and the second one was basically about the role of lawyers or the relevance of role of lawyers in mediation process. So, if you can enlighten us with a brief of this and the real place of lawyers in mediation, please, sir.
Basically, the litigants who come before this mediator, they are basically highly emotional and irrational. They will keep dwell on past occurrences, keep on talking, blaming the other person. To break that and make them come forward and bring towards the present and the future, we need the support of the lawyers. The lawyers know what exactly is happening. They have the understanding of their case. And if the lawyers are there to assist these litigants and the mediators, it will be an easier game for the mediators to, first of all, find out the crux of the matter, the needs and interests of the parties, and how to address that. And the lawyers know the details of the case of the litigants, much more than what they can tell us within 1 or 2 hours. Because, and then during the drafting stage also, as Rajesh has said, the lawyers know the law, they know the case of their litigants, and they are the best person to see that the interest of their clients are protected. If it is drafted by the mediator alone, mediator may not know all the intricate principles, the legal issues involved in this case. The mediator knows only what the parties tell the mediator. And even the parties may not know what is their legal effect. So it is very important that the lawyer is present during mediation. It is, according to me, the lawyer should be present there from beginning till end. And as Rajesh said, the role of lawyers in negotiation is an unexplored area. It has to developing field, and the lawyers also must become aware of the importance of negotiating for their litigants. Because instead of this adversary litigation in court, now the role of lawyers are being changed. The new generation of people are not interested in going to litigation and waste 10, 20, 30 years on partition or family court cases. So they like to have their cases finished off what this dispute resolved within as quick a time as possible. And there also the lawyers can assist them. And if for an easier resolution, the parties must be ready to pay more to the lawyers. So according to me, lawyers have a very central role to play in mediation. Thank you.
Thank you, sir. Sreelal, sir, would you like to add regarding the potentials of a lawyer in mediation?
Very much. Lawyers have their roles at three different stages. A party always comes to the mediation with all that kind of fear, anxiety, as they don't know what exactly is going to happen because they are appearing before the mediator for the first time. They think it is similar to something like a court. So the lawyer's role starts in preparing a person, a frightened person, to that of a very open-minded person. His mindset has to be changed. So that happens at the office. So by the time a party comes to mediation, there's a process involved in changing the personality of the litigant. Not only that, not all cases can be brought to mediation. 50% of the cases which come in for mediation are just sent back saying this is unfit for mediation or these are fit for something else. Now the choice of the case that should be taken up for mediation, the road starts at that stage. Once he identifies, he tells the client that this is something which is really good for mediation and you choose those cases which are really good. So it works out from the office itself. Now, as it stands in the country today, you have court annexed. Rarely we have the private mediation. You say it's a private mediation, or alternatively you convert it into conciliation or something else. So at that stage what happens is, you take it up to the court, brief the court as a counsel that here is a case which the court should consider for mediation. So there are three things. You choose the case of the client, prepare the client, get this brought to the notice of the court for the better interest of the party. For the better interest of the party, you get the court to order this for mediation. Once it comes to the mediation process, the most trusted, the most protecting person of a party who is otherwise worried, he sits next to you. This is simple, there's a movie which is named Mehuna. So anything, like I am here, don't worry about it. At that stage, the parties feel much, much better. They are relaxed to a great extent. And they know that even if they make a mistake, my guard is certainly there. And that's what the lawyer is. Look, in India, the concept of negotiator has not come in much. As early as in 1992, I had found institutes which were preparing lawyers or professionals into negotiators, professional negotiators. See, they don't argue and win over. These people win over the other side. How they do that is they do it emotionally, they do it substantively, and in all respects, very logically they try to present things. And the crux of the matter is a negotiator knows in putting what is of interest to his client as the thing which is the best for the other person. So he would say, why this is more important to you rather than to my client. Look at the way negotiator turns the whole card. And the other party starts feeling, what a wonderful thing. In fact, he has been so fair to me that he suggests something which is good for me. Can a mediator suggest something? Those people who have got trained, mediator cannot suggest something. So how does suggestions go to a particular party? Other than a mediator who is present over there, how much of the client know how to make suggestions? Look at this. Now the only professionally trained person is a negotiator. Now he becomes the medium or the vessel or the channel to communicate to the other side openly, giving up suggestions, etc. Now this is where the whole difference appears. How he can literally do something which the mediator cannot do. He is not barred from making suggestions. Look at that. That's the advantage that he has during that particular period. Now he also actively participates. In India, we have a saying that let only the clients talk, let the lawyers remain away. It's not for the lawyers. That is not correct. This is probably a team of the party and their person who can better represent, like in a court. They're not arguing over them. They're presenting things in such a manner, such a professional manner that the other side gets convinced that the whole proposal is actually the best for them. Now, this is what happens when a negotiator comes in. In short, what I would say is, think of a judicial system where you don't have good advocates. You have the clients over there. They are professionally qualified to present the client's case. Of course, in a different manner. It is more in an adversarial system. So is the importance of a negotiator in a mediation process. So if good mediators can bring out a good mediation, it would be much better if you have a negotiator associating with his own client. There are professional negotiators. Just a small difference. A negotiator thinks that once he gets into a negotiation or a mediation, he doesn't compare with the client without settling it. His success is in making sure that the matter is settled to the best possible to the benefit of his client. Therefore, maybe a little less beneficial, but still he and his client would feel that they have made a gain out of it. That is the role of a negotiator, and not coming back and saying, probably you don't have to accept it, you have to close it and that's all. That is where they say they win. Then there is a third stage. Third stage is, after the mediation is over. When is the mediation over? Anyone? When two people consent to certain things. Am I right? Oh yes, wonderful, we have agreed. Thereafter comes a role which is called documentation of the outcome of the mediation. Therefore, we all feel that even drafting is also part of the mediation. Think of the definition of the mediation. Two people who dispute come to a consensus. Once they come to the consensus, the mediator has successfully concluded. Now it is a formal documentation for the purpose of the system, so that the parties cannot withdraw out of it. That is a stage not just left to the parties. That is where the lawyers come in. The law, the consequences of the wordings, the consequences, after execution, and the lawyer says, once this is done, then they probably cannot back out, and he also has a responsibility of delivering justice, that is enforcing procedures that is supposed to. So there is actively a role for the lawyer, according to me, more as a negotiator and assisting or consoling person to the party, without whom the party is literally lost in mediation. That's why in the beginning I said, as is expected, the mediator does not get support from the lawyers, because probably 90% of us are not trained in negotiation. Though we say I did my level best in mediation, that is not the best at all. It is the level best according to him. And as far as the mediation is concerned, they still remain poor contributors. It is not that they are neglected or avoided. They feel that their role is limited and they don't come forward to do much more. It's in that context I said that I agree with the topic. Thank you.
So the fact that mediation advocacy involves a lot of negotiation is clear enough for us now. So Rajesh sir, I would like to put a question again to you. Do you think at some point, do you foresee a skill deficit in lawyers as a negotiator when it comes to mediation?
Yes, very, very much so, and that is exactly what Sreelal sir has said. One of the reasons is we are all negotiators. We negotiate with our spouses, our siblings, at your family, with your parents, with your colleagues, peers, and even with the auto rickshaw driver. And these days, even Uber, they have fixed one, but we still negotiate, right? So, we are familiar with that kind of negotiation, which I think is very transactional. We are splitting the difference. So he is asking, say, auto rickshaw driver, he is asking for 100 rupees, we are asking for 50. We split the difference, we end up with 70, 80, 75, that kind of negotiations. We are familiar with that. But what we do not fully appreciate is that there is a structured process to negotiation, as Sreelal Warrior sir has been saying. There is a structure to negotiation. It involves a bit of science, a bit of art. Look at international relations. Well, with Trump there, nothing is happening, but otherwise, normally, international relations are built on negotiation. That we value. Diplomats, high-level negotiation, we attach a lot of value to it. We look at hostage situations, which is not very common these days, but at some point in time, they were very big on hostage negotiations. And watch some movies. I've done a few. So they talk about it, there's glamour to it, unlike our auto rickshaw situation. So when we talk about mediation as a facilitated negotiation, we don't want to import the level of low-level, low-value negotiation, which is splitting the difference, but we would rather want to bring in the value of negotiation to a collaborative level. Not splitting the level, but splitting the difference, but winning together through different collaborative methods. As a negotiator, I'm sure the lawyers get involved in a lot of uses. If they are trained in negotiation, they will use a lot of techniques, best practices. They talk about tactics and even strategies to come up with the right results. So once we have the right results resulting from the proper techniques, when you go through the process of negotiation, generating options, evaluating the options, then trading off the options, getting to a closure, then I think negotiation makes more sense. The chances of having an efficient settlement will be higher. I'm not saying that if you go through the process of negotiation, there will be a settlement. It depends on other things as well, but there's a higher chance if you are properly negotiating. So to answer your question, I do feel there is a negotiation deficit, and I guess we will come to the reasons later, I suppose, but there is a deficit, skill deficit when it comes to negotiation and lawyers.
Thank you. I hope that we now have a clarity on the influence and role of lawyers when it comes to mediation. Now it's time for the audience. You can throw some questions, clear your doubts to our panelists. You can just stand up and raise your question. Please.
I do have a question. I want to relate an experience recently. I don't have a question, it's just an experience that I had recently in the matter where I'm looking for the defendant. I suggested that we go in for a mediation settlement. For mediation, the court sent us to the mediation center. The first day, we almost struck the deal, but because the party on the other side, the plaintiff, had to go urgently, we couldn't sign the document. He left. We were ready to prepare the document. He said he has to go, but he agreed to everything. So we kept it for a week down the line. 1 week down the line, he was there, his advocate was there, my party was there, but I wasn't there. I was stuck with another court. I said I'll come in a few minutes, please wait. But by the time I could get relief from the first court, the opposite counsel had drafted his version of what would be the mediated settlement agreement, and the understanding was that a check will be given for the amount. So the advocate on the other side, the plaintiff's advocate, wrote in that if the check is dissolved for any reasons, whatever be the reason, then the matter will not be settled, and then he'll have to pay the entire amount as is demanded in the plaintiff. My client said he needs 2 minutes to discuss and accept the image of what is written. I told him that any reasons should not be a reason because of check dishonor due to network issues and all that, which happened during this October to December January time, when there was a transition from the anytime you present the check, next day it gets cleared to up to 1 o'clock and up to 2 o'clock. A new rule had come in October. So I said that any reason should not be a reason that is not attributable to you. If there's fund in your account and everything else is fine from your side, if the check is dishonored for internet issues or something like that. So that any reason attributable to you. Nothing. I just wanted that. The other lawyer said, I will not change a word of what I have written. And he walked out. So now, right now, so that was in December and January. The case was posted today. Unfortunately for them, the charge was not setting, so it's posted now. I just saw it's gone to May. I would have settled it before the 31st of March. They lost. Now it will drag on. I don't have a problem, I will pay. That's my experience. So some lawyers just don't understand nuances, just to fail to see what is being suggested and add and see. That has to change.
Thank you, ma'am. Can I have one more question? Sorry.
We can look for other options. Why not instead of check back, why not you just do some other kind of transfer?
Now this is what that lawyer wanted. He wanted this check number and things to be written on the document. All that was written, everything that he wanted. So that to be honored, we signed the MSA, Mediation Settlement Agreement. It says if this check passes. So that's what the content is. It's prepared by him. He wanted the check number. My client offered the check number also. What more? So we can't give the
mediation always look for out of the box thinking,
correct.
Creative thinking. So since the lawyer is insisting on check itself and writing the numbers and all that, why not think of other ways of payment?
So we can't identify what will be UTR number or the NEFT or RTGS number in advance. That is something that happens on the day when the transaction happens. Only when we sign this agreement can we present the check and he can request it before. Oh, sorry, the bank.
According to me, it is something which can be easily settled.
It could have been resolved. That's what I'm trying to say. Sir. It could have been resolved. He had got his 4 lakhs in December, January, but now he's not got it even till May. And I am the better off than that. Whole thing is.
Can I take it? Interestingly, the dispute has now become that of the lawyers. In this. Parties have no problem. Party unfortunately asks the lawyer whether this is acceptable. The lawyer said, have a change. Now it has become, very interestingly what we do is, I'm just trying to give you a solution. We call it this way, can we have a lawyer caucus? Is that fine? Lawyer caucus. Unfortunately, the problem would be one lawyer would be in the court. The other lawyer he may not even be available. But otherwise, whoever has this difference of opinion on this, we have a lawyer caucus if the lawyers are there. Now, assume one particular lawyer had a reason to include that. As long as it is not made transparent to the other side and explained, the other lawyer may not understand. Now, we just ask this particular lawyer as to why he wants to incorporate that. Maybe if he justifies his no reasoning, the other lawyer would have said, I didn't know that. If that is so, there is no issue. You get this. Now, once he says this, and if this lawyer tried to convince, has a wonderful reason, as to, even in the absence of this particular cause, things can work out. The two lawyers would have resolved it by themselves had there been a second caucus. You get this one. It's not such a big issue. Wherever there is a dispute, there is a process by which this is being clarified by the parties. Partly, exactly the way we did it between the parties. This is just a solution that probably we can. Just one method. There are hundreds of methods to come over, circumvent these things. Thank you, ma'am.
Thank you, sir.
Thank you.
Another person was asking you this.
We have time for one more question. If anyone would like to do that.
Yeah, good evening, everybody. Just with respect, I'd just like to make a comment on the opening statement that I heard here today. The statement was just like this: that the mediators are poor cousins of the lawyers. I totally have to disagree with that. I think they are smarter cousins. I think they are the smarter cousins. So let us develop this venue and future such environments to make them far smarter, because mediators are making bridges, they are not burning bridges. Thank you.
Thank you, sir. Any more questions? So I would like to jump again for a very small question. So we were speaking about the influence of lawyers in the mediation process. can a lawyer in mediation can actually influence or shape the outcome of a particular mediation? That is, whether a lawyer can actually shape the outcome of a mediation. That is the question. Anyone can answer. Sir, John, sir.
Of course, if the lawyers are cooperative and collaborative and ready to go for a settlement, which is good for their clients, of course that has a great influence upon the parties. If a lawyer is not that collaborative and not supportive of mediation, it doesn't work. As the question that we have now asked. It depends a lot upon the lawyers. Especially in family law, we hear such a lot of complaints like that. So the lawyers have a huge influence upon the outcome of in mediation.
Sreelal sir, would you like to add something?
Who can actually come out with kind of a different, as you said, out of the box thinking and then come out with a different, altogether different solution? Who can actually speak out? Will the clients be able to come out with that? No, they are not really. They just focused, they see a very straight line. It is only those lawyers who are trained in negotiation who know how to bring out multiple options. They know that that is their role over there. And therefore, it is, I would say, a negotiator, lawyer participating in the mediation comes out with multiple options. And he would even say, I think this would be certainly acceptable to you. I really have a doubt whether anybody should be having a doubt. One sentence makes the whole thing different. Everybody starts thinking, like, is it for me? He says, for me. Now everybody is looking at himself, like, did he mean for me? And then the matra they will take it that way. That was the charm of a negotiator putting a suggestion. Now, just one simple sentence I'll tell you. Now, if I have a client of mine, the other side says something, okay? And when he makes a suggestion, he says, you see, it's a nice suggestion, you can think about it. I did not say accept it. The other client immediately starts trusting me. I am no more his enemy. You get this? Yeah. Next time, I can put in a suggestion, the lawyer can put in a suggestion, mediator can. Now, I was just wondering, for both of you, would this work out? Look at the way you coined the terms and then you put it. Before that, I've already taken, I've grabbed this confidence, like I'm in trust. And now if you put it, such as something like this, it could be something which nobody has thought about it. So I have worked out because I have been a wonderful negotiator. So I think this is the one which my client should have. But the way I would put it is, I believe, this should work out for both of you. Get this? And it takes everybody to a different level. So that's one possibility. There could be multiple occasions of this kind.
I'd just like to add something more to it. Today I had a mediation. And both the lawyers were cooperating with each other and they were putting their head together, thinking of out-of-the-box solutions. And all the two lawyers, the parties and myself, all together were actually brainstorming to find out a solution. That's the best thing to come out of a mediation. When everyone is trying to find out a solution. Everybody is cooperating and collaborating to find out a solution. That's the best thing that we can expect from a mediation. The best way. Thank you.
After listening to the views of our panelists, we feel that there seems to be a gap argue between the current role of lawyers and the potential role of lawyers. So let's see how to fix that gap, and let's also explore the reasons for this gap. Sreelal sir, can we start with you? We can either quote with the gaps and then the reasons, or we can go ahead with both of them simultaneously.
So they're asking a question back to you.
Yes.
Okay.
I was expecting this.
Lots of institutes which have come up. How many of us, I will also take a responsibility, starting from MCPC, how many of us have actually created a plan or a program for lawyers who participate in the mediation? We have been training mediators to such an extent. Very rarely you have some kind of an awareness in mediation for lawyers. And that too, if there are 6,000 people, 60 would be invited. Nothing. Instead of which, it is the responsibility of all those procedures of mediation to make sure that there are training process for lawyers in negotiation, and all these roles, all the three stages roles. That is when a lawyer becomes prepared, and that's probably the first time you would know that, oh, I have so many roles, so many things to do in mediation. But if they are not aware of it, how do you expect them to be participating and then sitting here and saying they're very bad people in mediation? You understand? It's our responsibility that we have created lawyers, or we have not created lawyers who are good for mediation. And they come with the, literally, like come in the lawyer background, the arguing lawyer background. One small difference between the arguing lawyer and a principal negotiator is, there's something called principal negotiation. Probably most of us will have got what is principle? I care for you. I am putting a suggestion which probably the others should certainly welcome. Are you getting my point? So we ask our clients, one simple technique that we normally have is, the client knows what he would not resist. Because they have been much more closer. We have just come today or a few days back. But they are living together for quite some time as partners in a partnership, as neighbors in boundary disputes, as husband and wife in family disputes, and any kind of dispute they would have remained closer for some time, and that is the reason why they have a reason to fight now. If they were daughter strangers, they would not have fought. So they know everything about the other person. So I ask my client, look, what is that probably he is looking at? Getting my point. Now he says, so sir, this is what he is probably looking at. Now, a good negotiator would sit with the client and say, you put in a suggestion, something short of it. And if she doesn't have a problem, the other person, accepting to the other person's demand 10 lakhs, you suggest 7. Let your own lawyer say, you can be more reasonable, why don't you? That again, literally, makes you more closer to the other side. You know that you can go up to 10, 7, and one simple sentence. Please understand. Understand who? Your opponent. Understand? And then look, something more. They say 9, at least 8 should be reasonable, I feel. Now who is speaking for whom? I am always being concerned about the other person. I know what our understanding is. You get that one. Now, if they are happy with it, if they are satisfied with it, it is principle. There's a need. She is saying she is what I need for 8 lakhs. That's going to serve a lot. So this it's called principle in the sense it serves their need, it serves her need. So this is how a good negotiator, he doesn't go in for bargaining. What we do on a daily basis is bargaining. We don't get into the stage of bargaining to that cheap bargaining. We put it as good suggestion, a concerned suggestion for the other person. If you learn to present it that way, then you become the best negotiator, a good lawyer who can literally win over the mind of the other person. Okay. So this is something, like we should be thinking about training people and training lawyers to become negotiators. Not necessarily that it should be a lawyer. Anybody who has got a knack of presenting things with a bit of show of concern, that is enough. And he becomes a good negotiator. Thank you.
Coming back to the question, how to narrow the gap between the real role of lawyers and what the lawyers are doing now. I'm going to flip the script. Do you think that the lawyers look down upon mediation as a lesser process?
You can say yes.
Can we have a show of hands, please, so that
Normally, when we are doing mediation, none of the senior lawyers ever come there. They avoid it. And even the lawyers, if they come, sometimes I have to call them directly. And when they know that it's me, they will come. Maybe if another mediator calls, they will not come. So there is an inherent, I will not say conduct, but the lawyers actually do not understand. Maybe because of that. They actually look down upon mediation as a lesser process. Compromise even the Supreme Court judges and High Court judges refer high profile disputes to retired judges who does not know anything about how to conduct a mediation. So that is a well-established dispute resolution system, as a adversarial system. Mediation is a new one, the new kid on the block, and there is a bit of avoiding. That's a lesser place. We avoid that. And I can even name the advocates who has directly told me, I never thought that I'll ever come to mediation. Thank you.
Would you like to jump in, Rajesh, sir, to what Sreelal sir and Pallath sir were saying?
Oh yes. I'm going to cover this lack of experience in their presence with some theory to it. I see three problems. One, I think, is a conceptual issues. Most people don't understand mediation as a facilitated negotiation. People think it's mediator's game. Parties go to a mediator, they settle, mediator intervenes, and there are behaviors of mediators which fuel that as well to a great extent. So the conceptual reset has to happen if that gap has to be avoided. Blame it on the education. Do you know in LLB, until 2021, nobody studied mediation. Oh, nobody studied much anyway. But nobody studied mediation. Now, it's a clinical subject. You know what it is? It's a clinical subject called ADR, and we have arbitration. And most teachers say we teach arbitration because it's easier. They are more familiar with it.